Have a seat, please. Representatives of the applicant and the respondent and the public, good afternoon. Are you ready now for the answer? I think we start with the applicant. You have 30 minutes, as I told you in the morning, to respond. 30 minutes from now.
Thank you, Honorable President and Honorable Justices of the Court. I will start with the questions put to us by Honorable Judges. And questions number 1, I am not so sure if I will be able to pronounce the names properly, so Honorable Judges, so you will excuse me. I'll start with Justice Chafika. Questions was what the applicant names and whether he has ever changed his name in his life. And the answer, the reply or the response is the names of the applicants are John Robert Penessis, and the names has never been changed before. And the second question from Honorable Justice was, will you be willing to undertake a DNA test to prove the relationship between the applicant and the first witness? And the answer was straight yes. The following question was from Honorable Justice Matuse, if I'm not mistaken, which was regarding to the birth certificate that the original was torn by the applicant himself at the domestic court level. Whether do the applicant can confirm of the assertions of the respondent, and our response is he has never torn his birth certificate. And the question from Ben Rafa, Honorable Justice, the question was, did Robert Penessis lose his Tanzanian nationality after having acquired other nationality, or has he never had Tanzanian nationality? And the response is he has never lost his Tanzanian nationality and has never taken any other nationality, and he is still Tanzanian according to the law. And the questions from Honorable Justice Nyoko Gerard were 4 questions. One was, have you ever, the applicant, requested for a resident permit, and if yes, can the court see the original of the letters, also certified copies? And the answer from the applicant was no, he has never requested a resident permit, since he's a Tanzanian, so he did not need one. And the other question was, does the applicant has a Tanzania passport? And if yes, can the court see the original copies? And the answer from the applicant is, the applicant has an emergency travel document number AB 05135590, which clearly marked ordinary passport on process. And the same was taken, the original copy was taken by the respondent. And the third question was whether the applicant has lodged an application in the court in 2006, and tell the court if the applicant have exhausted local remedy. The response to the question is no, the applicant has never filed any case, and it was the duty of the parties alleging to prove the same by submitting the document to the court to prove that actually there is a pending case as to that question. And the applicant has exhausted, to respond to the B of the question, is the applicant has exhausted all local remedies as he filed appeal to the Court of Appeal of Tanzania, which is currently the Supreme Court of the land, and the court ruled against him, so there is no any other local remedy to be exhausted. And question number 4 from Honorable Justice Gerard was, did the applicant refuse to cooperate and meet the South Africa official to clarify the alleged South African nationality? The answer, the response to that is, the applicant was not, the applicant was not at any time informed of the visit of the South African official to see him. And the other question was from Vice President Honorable Justice Kioko. And question number 1 from him was, the respondent state that the original documents are with the applicant. Can you ascertain this? It was the both sides. And the applicant's response to this question is, normally, a detainee or a convict, while in prison or into a police custody or detention, has to surrender all his property, papers, documents, and anything to do with that to the prison warden. Hence, it would have been easy for the respondent to access them, and they have authority to do so. And question number 2 was, which original documents are in the possession of the applicant or respondent relating to the citizenship or nationality of the applicant? And the response, Honorable Justices, to that question from the applicant is, the applicant has the birth certificate, and the emergency travel document and the original were taken by the respondent, so he has only copies. And one of those copies, the only copies that he had, are also submitted before this honorable court. And the question from President Honorable Ore was, if you are Tanzanians, what document do you have to show proof? The response to that question, Honorable Justice, is a Tanzanian's birth certificate, which the applicant have a Tanzanian's birth certificate number 00001642, and his mother, and both their parents, applicant parents, are Tanzanian, and that's also confirmed by Section 5, Subsection 2 of the Tanzanian Citizenship Act, Cap 357, which provide as follows. Every person born in the United Republic of Tanzania on or after the Union Day shall be deemed to have become and to have continued to be a citizen of the United Republic of Tanzania with effect from the date of his birth, and with effect from the commencement of this act, shall become and continue to be a citizen of the United Republic, subject to the provision of Section 2 of the Act, sorry, Section 30 of the Act. So the documentation, Honorable Justices, that the applicant has is the birth certificate, which also the original was taken away by the respondent, so the respondent can produce. The second question was, do you have any other nationality? If yes, which are they? And the response from the applicant on that question is that the applicant has no any other nationality. Honorable President and Honorable Justices, those are the response of the question put to the applicant by the court. Now I will proceed with our queries as to the respondent's submission yesterday. The applicants would like to put these questions that may be recorded by the court that is follow. If the applicant is a real South African, how come that the respondent could not have submitted any document communicated to them by the South African authorities as to the status of the applicant? It was easy for the respondent, at least for the sake of the justice to be done before this honorable court, to ask the South African embassy or authority to supply with a letter to prove that truly the applicant is a South African national. And other queries we have is, we all know, and honorable judges particularly from the SADC members countries, knows and they can confirm that all citizens of SADC member states to visit any other SADC state, one, do not require or need a visa or apply a visa to visit any other SADC member countries, which South Africa and Tanzania are member. So how come that the alleged South African passport holders had a visa from South Africa to visit Tanzania? Other very interesting questions, Honorable Justices, is how come, as they are alleged by the respondent, how come that the United Kingdom and South Africa didn't write any letter and the same be submitted to this court as a confirmation that it is true the applicant is a citizen of the both two countries, which it is very strange because South Africa also do not accept dual citizenship. So it is not possible for a British national to be also a South African national, to hold both nationalities. And more interesting also that a national of the United Kingdom is still in custody, while we normally know that the United Kingdom can use a lot of pound to rescue even one citizen in the middle of Central Africa. The other question is, if the allegation that the applicant is a citizen of the said two or more countries, how come the respondent could not produce before the court any original documents of the alleged passport, or even produce a certified copy or copies from the respective alleged embassies of the said countries, which Honorable Justices, it was very easy for the state to request just for certified copies. That is not enough, Honorable Justices. How come that the respondents were not able to produce and tender before this Honorable Court a certified copies by the prison at Bukoba as to the status of the three alleged passports under custody, as we know that if a detainee is in prison, all the documents must be under the custody of the authority or the warden of the prison. Honorable Justice, the respondent also claimed that the applicant was charged in the case number 35 of 2010, and the charge was unlawful entry into Tanzania. If that is in affirmative, if it is an unlawful entry, then how the applicant was allowed to apply a resident permit? Then the respondent claimed that applicant was charged after they applied for resident permit and that he did not make any follow-up. Then it was when he was arrested and charged. So the question is, how long does it take for one to make follow-up after he has requested for the resident permit? And this question was also raised up by the honorable judges yesterday. That's how long was that? And the applicant told her that he has been in Tanzania for the last 40 years or so, without any interruption until 2010. The respondent also claimed that the applicant has not exhausted all local remedies. The question is there any other Supreme Court in the United Republic of Tanzania? Because if there's any other Supreme Court apart from the Court of Appeal, then the applicant will not have exhausted local remedies. The respondent claimed that the application is out of time, and they have cited the case of Majuru, the case that the limitation, which they allege that the limitation of time is 6 months, according to that question, according to that case. Now, the question is, on what provision in the African Charter or rule of the court provide for the limitation to 6 months? Because further to that, the case of Majuru, which was cited by the respondent, is the decision of 2008, while the case that we cited in our submission is the case of Dr. Farouk Mohammed Ibrahim for the Sudan, communication number 386 of 2010. So which ones take precedent, 2008 or 2010? 2010 said the limitation is any reasonable time. It did not set any limitation of 6 months. The respondent claimed that the birth certificate of the applicant was a forged one, and this knowledge they had it since 2010. So why didn't they not prosecute the applicant since 2010 to date? Honorable Justices, the respondent also, during their submissions, submitted that the respondent claimed that the applicant is being held awaiting for his full conditions for fulfill his condition for deportation. If that's so, why then he's detained with others' criminal convict? Why is he not out for bail or under special arrangement that is outside for bail? The respondent further submitted that in their submission that the birth certificate is not approved to show one is a citizen. So could they provide, now our question is, can they provide with a certification or a certificate to show that, apart from a birth certificate, there is a certificate to prove that one is a citizen? And you have seen also the section that we have cited just above, that the Citizenship Act clearly put that when you are born in Tanzania, you will continue to be a citizen of Tanzania. Further to that, the respondent has provided that the applicant is detained because he is awaiting to be deported. For how long then the deportation, how long will the deportation last? So could it 10 years, 50 years? And why the South Africa or United Kingdom could not just come and take their own citizen if truly the applicant is a citizen of those two countries? Those honorable justices are our questions and all our reply to part of the applicant respondent's submission. But also, if I have 2 questions left, the applicant's mother or the witness number 1 asked me to pray before this court that she had just a minute to clarify something.
Okay, granted.
Sorry, Honorable President, he said that she's not feeling well, so she can't stand to clarify anything by now.
Okay, okay. Sure.
Excuse me, Honorable Judges, if we can also say something. We were wondering as... If you can help, please. We are glad that she said she would not be able to provide any further evidence before this court, because we were wondering, it's not even in the timetable, and we thought it's time now for responding to the questions by the judges and perhaps submissions by the applicant. So we are glad that she's not going to give any evidence, because we thought that session is closed. Yeah, and it should be so. There has to be an end to everything, especially litigation.
Okay, but I will give you time after and we will appreciate. Respondent, you have the floor.
Thank you, Honorable Judge, Honorable President, Honorable Justices. The first question posed to the respondents was, will we be willing for the applicant to take a DNA test? Our response is, if the applicant is willing to take a DNA test, we have no objection. However, let it be known that a DNA test is only confirmation of one's biological history. It can only confirm who gave birth to the applicant. It is not proof of one's nationality or citizenship. In Tanzania, to ascertain one's nationality, the Citizenship Act is applicable, as it provides the way in which one attains or acquires citizenship by birth, by descent, and by naturalization. But we have no objection to a DNA test being done. Second question posed was, do we have any proof that the applicant changed his name? Yes, we do. And we'd like to respond to this question as we respond to question number 16, where we were asked, in the file, the respondent stated the applicant has different nationalities. What is the evidence it is the same person? Our contention is that Robert John Maitland, Robert John Rubenstein, and Robert John Penessis are the same person. We have a copy of a certificate of change of name reflecting that Robert John Maitland changed his name to Robert John Rubenstein. This is issued by the South African Embassy in Greece on the 24th of December 1999. A copy of this was attached to our reply. Therefore, Robert John Maitland and Robert John Rubenstein are one and the same person. And it was Robert John Rubenstein, also known as Robert John Maitland, who produced the birth certificate reflecting himself as Robert John Penessis. So this is how we've made the linkages between the 3 names, all reflecting the same person. The third question was, have you approached the South African Embassy, the Greek Embassy, and the UK government to confirm that the person holding the passports is Robert John Penessis? We have not approached the Greek Embassy. We have approached the South African Embassy. And as a result, their officers went to Bukoba Central Prison to start initiating deportation processes. They were to take fingerprints as part of their procedure of the applicant. However, the applicant has strenuously refused to meet with officials from the South African embassy and to cooperate with them. But we have been following up with the South African embassy. With regard to the UK government, we wrote to them with a copy of the British passport of the applicant, and their response was that a British passport clearly reflects nationality of the holder of the passport. However, we did not follow up with the British embassy, as we were in negotiations with the South African embassy, and also as the evidence that we had on both passports was that his nationality is South African. So this is the avenue we're pursuing to date. Fourth question, how did you ascertain that the applicant has two nationalities? As we've been stating in our submissions and during the course of the hearing, is the two passports that were found in possession of the applicant. As a result of these passports, one being British, showing he's British citizen, the other showing he's a South African citizen. This is how we came to discover that he's got two nationalities. The fifth question is, where are the original passports? We believe that the original passports are with the applicant, as he has never produced them. When the applicant came to make his application for his residential permit, he came with certified copies of his passports. He also had his actual passports, of which the immigration officer looked at his passport and retained the certified copies and told him to complete procedure for application of his resident permits. Therefore, the applicant himself, the passport was returned to the applicant to enable him to continue to reside in the country lawfully as he's pursuing his residence permit. So our position is the applicant himself is best placed to inform this court, to inform the respondent state where his passports are. It's noted that during the trial, certified copies of his passports, they were tendered and admitted as evidence. The copies were certified by an advocate, the same advocate who was representing the applicant during his trial, during his appeal at the High Court, and during the Court of Appeal. Therefore, it stands to reason that at some point, the applicant had given his defense counsel his passports to certify. Therefore, our contention remains that the applicant is best placed to inform us all where his passports are. And further, the applicant has continued to dissuade our efforts in securing his passports by giving contradictory information. It's noticed that during his trial, the trial proceedings have been provided. The applicants informed the court that his passports were with the respective embassies. He was asked to produce some sort of receipt or check of some sort to reflect that they were indeed retained by the embassies. He did not do this. And then later on in the same proceedings, he contradicted himself and said that his passports are with the Muleba Immigration Office, therefore producing a roadblock towards our own efforts at finding out exactly where his passports are. So based on this information, the respondent state strenuously believes that the applicant himself is best placed to inform us all exactly where his passports are. Another question we're asked is, where is the original application for residence permit? Do you have it? If so, can you provide the application to the court? The position is we do not have the original application for the residence permit. What happened is when the applicant approached the immigration officers, he went with certified copies, an affidavit. Upon his arrival there is when he was informed that his application is incomplete, and he was given an immigration form to fill out and to return. So he left with the immigration form and he left with his original passport. He was meant to complete filling out the application form and return to finalize the process. Therefore, the application form itself and the original passport is still with the applicant. He's best placed to inform us all exactly where the residence permit, the application for the resident permit is, and his original passports. It should be noted that the process was never completed for his residence permit. Another question we were asked is, how can you explain that a person, irrespective of his nationality, can be in detention for several years running after having served the entire sentence handed down by the competent court? We'd just like to go through the background again of this matter, and to explain that the applicant, he was convicted and sentenced with the offense of unlawful entry and presence in Tanzania, which is a compounded offense. The sentence was a fine of 80,000 shillings or 2 years imprisonment. The applicant paid the fine, so he was never imprisoned for the offense. He appealed against his conviction and sentence to the High Court, which upheld his conviction and sentence. However, during his appeal at the High Court was gracious enough to assist him with producing additional evidence which he was unable to at the lower court. In the process of doing this, he was trying to submit a document, and he tore this document in court himself. As a result of tearing this document before the Honorable Judge, he was found in contempt of court and sentenced to 6 months. So he served the 6 months imprisonment, and he finished that period. He further appealed to the Court of Appeal against the High Court decision with regard to his unlawful entry and presence in Tanzania. The Court of Appeal upheld the decision of the trial court. Therefore, as the justice system had found that he was unlawfully present in Tanzania, the Minister of Home Affairs issued a deportation and detention order on the 17th of December 2010. These two orders, they are issued simultaneously as part of the deportation process. The detention order is to facilitate the deportation so we can contain the applicant. However, as we've said several times throughout these proceedings, the applicant has refused to cooperate with the respondent state and enable procedure for his facilitation. He has refused to have his fingerprints taken. He has refused to meet with officials from the South African Embassy. As a result, the detention order continues to stay. Further, the laws of Tanzania, for example, Section 27(6) of the Immigration Act, provides that a deportation order shall remain in force for the period specified unless sooner varied or revoked by the minister, or if no period is so specified unless varied or revoked by the minister. So as the deportation order still stands, the detention order continues to stand. Another question we asked is, why did the deportation fall within the Minister of Interior? Why was this order not executed as immediately after it was ordered? I believe I've answered the second part of the question, but the deportation order fell within the Minister of Interior as he's the minister responsible for immigration matters, and Section 27 of the Immigration Act confers powers to him to issue deportation order. Immigration is within the Ministry of Home Affairs. Another question we were asked is, are there no procedures for a forceful deportation? No, there are no procedures for forceful deportation in the United Republic of Tanzania. Further, deportation is subject to consent between the receiving states, and it should not be contended by the deportee. The deportee should be in agreement of where he's going, which in circumstances we're facing, the deportee is not in agreement. We were asked, did Penessis lose his nationality having acquired other nationalities, or he never had Tanzanian nationality? Honorable judges, the applicant has never had Tanzanian nationality. He's failed to prove he ever did. Therefore, the circumstances were never that Penessis was in a position to lose Tanzanian nationality, as he never had Tanzanian nationality. Another question we asked is in the Tanzanian system, is there a judicial remedy against an administrative deportation decision? There are no administrative remedies, however, there are legal remedies, and this was canvassed during our preliminary points of objection raised during the oral proceedings, where we stated that the order made by the minister responsible can be challenged in a court of law under the Law Reform Fatal Accidents and Miscellaneous Provisions Act by praying to the court to quash the decision of the minister. This is a remedy to those aggrieved by an administrative body or authority under Section 17(2) of the same Act. And in these circumstances, the applicant has not exhausted this available remedy. The objective of the judicial review would be for the court to assess the minister's order and, if it so deems, reverse the minister's decision. This is the logic behind the judicial review. Another question we're asked is, the respondent stated the applicant's birth certificate is forged. What is the respondent state planning? When is the respondent state planning to prosecute the applicant? The discretion lies within the respondent state after consultations with various stakeholders from the police, the DPP, fraud. This involves internal mechanisms, and we cannot provide a definitive time frame at this point in time. Another question we're asked is, the applicant entered Tanzania territory with an entry visa in a South African passport. Can we have a copy of the South African passport reflecting the visa? As indicated earlier, what we have are copies of the certified copies, and this can be produced. We have a copy of the applicant's South African passport with a visa showing he entered the United Republic of Tanzania on 22nd May 2009, valid until 21st August 2009. He was granted a 90-day stay. This was a visa that he was granted. We also have a copy of the applicant's British passport, which also reflects he had a holiday visa, which was also valid within a very specific time frame. Another question we're asked is, which original documents are in possession of the respondent relating to the citizenship or nationality or residence of the applicant? As we've mentioned earlier, the passports, we believe, are still in possession of the applicant. However, we have the judicial decisions. We have the High Court judgment, we have the Court of Appeal judgment, and certified copies of their decisions can be made available. And just to reiterate that the immigration officers could not retain the applicant's passports. These had to be returned to the applicant so that he continue residing in the country and going about his business lawfully. Therefore, they were never in a position to be able to retain the applicant's passports. Another question we're asked is with regard to the Vienna Convention on Consular Rights. Yes, indeed, United Republic of Tanzania has ratified the convention. And just to add to this, there were attempts with the South African embassy to provide the applicant with consular assistance. However, he strenuously refused. We actually have a copy of a note verbal. We have a copy of a note verbal whereby officers from the South African embassy have written to the Ministry of Foreign Affairs saying that they did go to offer their consular services, but the applicant refused to cooperate. That's amongst the documents that we pray to supply the court with. And I believe I finished the questions that were asked. My colleague will follow up with the follow-up.
Yes.
Honorable judges, before we conclude on our submissions, we'd also wish to emphasize on the following few points. One, based on Article 3 of the protocol, as well as Rule 26 of the protocol, we wish to emphasize and reiterate that this court does not have jurisdiction to deal with the applicant's application for the reasons that we provided yesterday. Regarding the issue of jurisdiction, we talked about the letter written by Georgia Penessis It was more of seeking an advice from this court rather than an application to pursue the respondent state. But also regarding the jurisdiction of the case, that particular letter was based on Geneva Conventions, which are not applicable, are not envisaged under Rule 3 and under Rule 26 and Article 3 of the protocol, because those provisions deal with human rights provisions and not humanitarian provisions. But also we talked about the issue of evidence, that the application is full of requests to evaluate evidence which has already been determined in the national courts and conclusively decided by the courts of the national, by the national courts of the respondent. Regarding the admissibility of the case, we would wish to further emphasize that the applicant is yet to exhaust local remedies, and that his application should be dismissed with costs. Yesterday we mentioned that he is yet to even challenge the administrative decision by the minister to deport him. This administrative order to deport the applicant can be challenged before the National Courts of Tanzania via the law on judicial review. And also the applicant is yet to appeal on various habeas corpus applications he filed before the court. For some of the applications which were struck out, he has a remedy of reinstating them, but also for applications which were dismissed, he still has a right to appeal against those decisions. But also we mentioned about the new application filed in 2016, which is a very new application. The applicant needs also to exhaust that remedy, because in that application is asking the High Court, is actually suing the Attorney General, the Director of Immigration, as well as the Minister for Home Affairs, and is actually requesting the court to declare him a citizen. So it's a very new case. We have a copy of it right now. We'll also file it in our submissions, but we have a copy right now. It's a public document. It's in the High Court of Bukoba, in the High Court of Tanzania at Bukoba. And I also wish to contest the argument by the counsel for the applicant that the case of Majuru is an old case. It depends on his argument. He cited the case of Ibrahim, whatever, that says that that talks of any reasonable time. So the question again comes, what is reasonable time? Is it 20 years? Is it 6 months by Majuru? These are decisions of the same commission, and we are not aware of the fact that this decision has been nullified. So it has to prove before this court what reasonable time is reasonable time. If the issues of citizenship are very serious issues, you can't just take 3 years. But where is your seriousness? People will question about your seriousness. So we also dispute that case because it's not, based on a specific time. It leaves the discretion on reasonable time. What is reasonable time? That's a question to be decided. We also cited a number of cases to support the fact that exhaustion of local remedies is a principle of international law. We cited the cases of Saringon, Sirac, cited by himself, and the case of Dauda Jawara, and we pray that they be used against his application. Honorable judges, let me also talk quickly about the testimony, evidence given by the witness for the applicant. We actually dispute the evidence given by the witness for the applicant because she was not clear, she was not consistent, she was not precise at all. She couldn't even prove that her alleged son is a citizen of Tanzania. Every time she was being questioned, she went out of context. She wasn't giving straight answers, and it is our opinion that our evidence should be dismissed by this court. And also, she claims to be an alleged mother of the applicant, but she never testified before the national court in the case which was filed against the applicant. So she can't just be a witness here before this court. We think that it was very important for her as a mother, if indeed she is the mother of the applicant, to testify before the national courts on the fate of his loved son, if indeed he is her son. For the witnesses called by the states, we wish to state before this court that they were so clear, so consistent, so precise, and to the point, and they managed to prove before this court that in issues of citizenship, the applicant has the onus to prove. Under our laws, the onus lies to the applicant to prove that he is a citizen of Tanzania. That is one of the things that was proved by our witnesses. But also apart from that, our witnesses proved that the applicant possesses passports from 2 countries, the UK and South Africa. Something that cannot, happen to a Tanzanian, a person who is a Tanzanian. But also the applicant applied for residence permit, something that again cannot be done by a citizen of Tanzania. Our witnesses also proved that the applicant used to enter Tanzania using visas, something that cannot happen to a person who is a Tanzanian. But also we have the judgments of the national courts, the 3 judgments proving that the applicant is not a national of Tanzania. And we really pray for the judges to read those 3 judgments because they will enlighten you on the issue of citizenship as you will be considering this matter. But again, our witnesses, or rather the team for the respondent state, proved that the applicant failed to provide his Tanzanian passport. He actually ended up talking about the emergency travel document, which again I have to make it clear because the records are also before this court. This is a very document that was torn. It's not a birth certificate. I talked about it yesterday. It's an emergency travel document, an original copy of an emergency travel document that was torn by the applicant before the National Court, and it's in the record of the judgment of the High Court. And he was actually punished for contempt of court for that purpose. So he has the original, he has the burden to bring the original. And the respondent state should not be subjected to bring such a document because the original is in the hands of the applicant. It's in the record of the High Court judgment. Honorable judges, our witness also managed to prove that the applicant was in possession of a forged birth certificate. In any case, we feel that, of course, the discretion to prosecute the applicant lies in the respondent state, and we say that there's no time limit for criminal offenses in Tanzania. And in any case, we feel that the deportation order is much more important right now when we are considering all these issues, but we are not ruling out the possibility to prosecute him. It lies in the discretion of the respondent state. In conclusion, honorable judges, I would like to state that citizenship in Tanzania is regulated by law. It is just not granted like a birthday present. Honorable judges, we pray that this application be dismissed with costs to the applicant. Thank you, honorable judges. We submit for your judicial consideration.
Thank you, respondent. The applicant, you were requesting your witness to take the floor. But no, it's okay. I will not allow the witness to take the floor because the witness on the other side may want also to take the floor. If your witness want to pass a message, I think she can just tell you. Excuse me, yeah. She can just transmit the message to you, and you will just tell the court. And we cannot also allow some new evidence. Okay, I will also
Honorable President and Honorable Justices, thank you first for that. What the witness wanted to clarify is the questions asked yesterday during the cross-examinations about Robert John Penessis being his son or adopted. She said she could not understand the question because the translation on his headphone was in Swahili, and she wanted to clarify that Robert John Penessis, he is her biological son. That is what she wanted to clarify, and that is not a new evidence, Honorable Justice.
You want to say something?
Thank you, Mr. President, honorable judges. We'd like to strenuously raise our apprehension and the fact that the applicant at this stage is continuing with her testimony, continuing with her evidence. I think what he said was this was during her cross-examination. We're opening up a Pandora's box. In this regard, we'd also have to call our witnesses to counter what was stated. It's an afterthought. The records were clear. What transpired yesterday in court, and in this regard, we'd also like to state our position, which is that Robert John Penessis is not her son.
Okay.
Thank you.
Okay, so no, anyway, we stop this discussion. In any case, it's not a new affirmation because yesterday she said that it is biological son. That's what she said. So it just we just repeat what was said yesterday. So there is no room for discussion on that basis. My colleagues, I will give you the floor for you to follow up with some questions, if you want to follow up. But I will start with Justice Matusé. Justice Matusé.
Question to the counsel for the applicant. You have heard the respondent stating that what was torn at the court at the domestic jurisdiction was not the birth certificate, but rather the emergency travel document. Is that correct? Did you hear that? Right. Now, can you confirm that your client has indeed torn that emergency certificate? First. Secondly, since it was not the birth certificate, if you have heard that it is not, according to the respondent, can you assure this court that you are in possession, or your client is in possession of the original birth certificate? Thank you.
Yes.
Honorable Justice, let me start with the last question about whether he has, the applicant has the original birth certificate. According to the witness number one, who is his mother, he's assured me that the original certificate is in Muleba. He can get it in Muleba, but he's also not so sure if it is in the custody of the applicant, but she knows that the applicant had an original certificate, so probably it is in Muleba. For the first question, I can't confirm that the applicant has turned up the emergency travels document. So I can't confirm that, Honorable Judge.
Okay, to be fair, if a party respond to any question, I think the other party can also take the floor to reply or to clarify something, so that we keep fairness. Judge Ben Saoula, are you okay? It's okay. Justice Ben Saoula.
Oui, merci Monsieur le Président. Bonsoir tout le monde. Moi, j'ai deux questions à poser au requérant.
Attendez, juge Ben Saoula.
Ma première question au requérant est la suivante. Pourquoi Madame Pénélope n'a jamais assisté aux procédures engagées contre son fils en 2010? C'était quoi le problème? Ma deuxième question, vous dites qu'il a été, le défendeur dit que le requérant a été condamné pour avoir déchiré le document de voyage. Ce qui veut, nous concluons donc que ce document de voyage déchiré est déposé comme pièce à conviction devant le tribunal, puisque c'est devant les juges que le requérant a soi-disant déchiré ce document de voyage. Donc, est-ce qu'on confirme que ce document de voyage est une pièce à conviction déposée devant le tribunal ou la cour qui l'a condamné? Merci, Monsieur le Président.
Thank you, Honorable Judge. I will also start with the last question. The last question that the applicant torn the document and he was punished for the contempt of court. If you read the decision of the Court of Appeal, you will find on the last, almost the last page, that the Court of Appeal nullified and declared that all the findings and the conviction of the applicant for contempt of court is a nullity. So it was nullified, everything was nullified. And as you all know that, honorable judges, when the court nullify any proceedings, then it means there is no any conviction has been found. And first question was why didn't the mother of the applicant attend the court? Excuse me, Honorable Judge, so that I can confer with her, because I don't have a direct answer to that.
Objection, Honorable Judges. This thing cropped up yesterday as to why he did not. It was a question. The question as to this one. If you could help. Is it on now? Okay. Honorable judges, this very question was posed to the witness for the applicant yesterday, and she couldn't answer it. So she cannot answer it today. She should be stopped from answering it today. We beg and pray. Taken by events.
Thank you.
Unfortunately, Honorable Justices, my learned friend is controlling the court. The questions was put by the court.
Is it a question from you are responding to a question from Justice Ben Saula?
Yes, Honorable President.
Okay. Justice Ben Saula is responding to your question. Is he responding to your question? Okay, go.
Yeah, thank you, Honorable President. The witness response to that is that she could not attend the proceedings of his son during the local or municipal court because she was ill. She was very ill, and she can prove that if the court saw need.
Respondent. Okay, respondent, just to clarify, since he was responding to a question of Justice Ben Saula, I think he can respond, and when you take the floor to reply, then you can make your reservation.
But I'm worried about...
Now you can do your reservation. We just appreciate. We are not taking a decision now. But your observation, we take your observation in account. Yes. No, please. Justice...
No, on that question.
On that question.
On that question. Yeah, actually, yesterday I did ask that question to the. Actually, the microphones are on. I don't know what the problem is. Yesterday I asked that question of the mother of the applicant, and I think the answer that she gave me was that she did not know. I asked, where were you when criminal case number 35 of 2010 was being heard? And I don't recall exactly whether she said she doesn't know or something in that regard. So we've taken note of what has been said now, and I don't think that the respondent needs to worry too much about that. We were not sleeping. We know what we got yesterday and what we are getting now, so it's fine.
Justice Benachou.
Merci, Monsieur le Président. Pour l'État défendeur, dans vos réponses, vous parlez toujours du passeport au singulier. Vous dites le passeport. De quel passeport il s'agit? Du passeport de l'Afrique du Sud ou du passeport du Royaume-Uni?
Excuse me, Honorable Judge, if you could kindly go again, ask the question again.
Qu'est-ce qu'elle dit? Oui. Je vous ai entendu tout à l'heure dans vos réponses dire 5 ou 6 fois le passeport, en utilisant le singulier toujours. Je vous demande de quel passeport parlez-vous?
We can't hear the English. It's very...
It's too low.
It's too low.
We can't hear.
That's why they couldn't get what is said by the judge.
C'est OK? Vous avez entendu la question? OK. Deuxième question, s'il vous plaît. Toujours l'État défendeur. Vous avez dit l'avis d'expulsion. Mettez votre casque pour écouter les questions. Vous avez dit tout à l'heure que l'avis d'expulsion a été pris en 2010. 2010. Nous sommes actuellement en 2018. Cela veut dire que cela fait à peu près 8 ans qu'une personne est en prison. Sur quelle base juridique? Sur quel acte juridique peut-on détenir en prison une personne? Est-ce qu'un acte non judiciaire peut priver quelqu'un de sa liberté? Enfin, pour le requérant, est-ce que le jugement rendu par le juge pour outrage à magistrat mentionne en quoi consiste cet outrage? Est-ce que le jugement nous dit exactement en quoi consiste l'outrage à magistrat, même si cela a été annulé par la suite? Merci.
Thank you, Mr. President, honorable judges. I was making reference to two passports. There's a British passport and a South African passport. Both were I was making reference to a British passport and the South African passport. Both passports were tendered as evidence in court and they were admitted by the court. So we're making reference to two passports. With regard to the deportation order was issued on the 17th of February 2012. It's been 8 years. This is not a situation that the respondent wants to find itself in. There's nothing virtuous, there's nothing positive about reporting that you have someone who is detained in your prisons for over 8 years. But as we've been saying throughout these proceedings, the applicant himself has strenuously, ardently refused to comply with procedure to have him deported out of the country. This is our position. Thank you very much.
And if I may also add, if I may be allowed to add on that, on the detention order, it should be understood that the detention order is an administrative procedure done by the Minister for Home Affairs, especially for people who have been ordered to be deported. And according to the, is it immigration? The Immigration Act of Tanzania, it will remain to be valid until revoked by the minister himself. But of course, in between, an applicant is able to challenge, is not deterred from challenging the validity from challenging the validity of the detention order. And again, if we may make it clear, the applicant, after he was convicted, he paid his 80,000 shillings and he was free. But however, he was arrested in 2013. That's when the order of detention was given by the Minister for Home Affairs. If you go through those judgments we submitted before the court. So his detention started in 2013, and his detention is the way it is because he is not cooperating. For him to be out of the detention order, out of detention, he has to cooperate with the South African officials to provide his fingerprints so that he can be sent to his home country. He is not cooperating at all. So him staying in the detention order is because of his own doing and not the government of Tanzania.
Merci, Monsieur le Président, pour le suivi. Est-ce que, Monsieur le Président, vous pouvez demander à l'État défendeur de nous fournir une preuve authentique, c'est-à-dire faite par exploit d'huissier, dans laquelle l'huissier constate que le requérant refuse de coopérer avec les autorités pour sa procédure d'expulsion.
Respondent, have you heard the concern made by the court? Microphone.
My colleague submitted before this court that we have, is part of our list of evidence to be submitted before this court. We have a copy of the letter from the Ministry of Home Affairs, a letter which was written by the South African Embassy, talking about the applicant's refusal to cooperate with the officials of the South African Embassy to have his fingerprints collected. We have a copy of the letter. We can we can submit it before the court by providing a cover letter that it is from our office, because it is a copy, but we have it here. So that's one of the evidence that he's not cooperating. And apart from that, our witnesses yesterday, those people from the Ministry of Home Affairs testified to this fact. I am not from the Ministry of Home Affairs, even though we are coming here as government. The people from the Ministry of Home Affairs testified. These are the people who visit the person. These are the people who deal with the applicant in detention. They testified to that effect, that he's not cooperating. So him staying in detention, again, I repeat, is because of his own decision. Yes, because the government already gave an order to deport him, even tonight.
Juge Benachou, ça va?
Oui, merci, monsieur.
Okay, yes.
Just to follow up, the letter that you have referred to, Ms. Mwaipopo, the one from the South African Embassy, is it in this, because I've gone through them and I did not see it.
Traduction.
Just a
No,
minute.
it's in our custody.
I'm told there was no interpretation.
Okay.
Is it okay now? Interpretation in French. C'est bon? I'm told there is no...
Interpretation in French.
Oh, this microphone is not working. Can I borrow your microphone? This one. No, it's not working. Micro. Can I have that microphone?
Allô, l'interprétation?
Yeah, I think the microphone is on now.
Oui.
Okay.
Yeah, I was asking that the letter from the South African Embassy, is it in this bundle of documents, because I've gone through it and I don't see it, or is it in the earlier documents submitted by the respondent state?
No, we have it now. It's not in the documents submitted earlier on, but it's part of our responses.
Oh, you have it now?
Today, yeah, we have a copy, and if you wish us to support it by an original letter from the office, we will be glad to do that. But also in our response to the court, I've just been reminded that we also attached copies of affidavits of the immigration officials testifying to the fact that they went to the detention to have the fingerprints collected from the applicant, and he refused. So we have copies of affidavit. It's
okay, and those affidavits are where? In this bundle? Because I did not see them again.
In our reply to the application, to the letter by
Okay, okay, the earlier response, okay.
Yes.
Very well. Now, I wanted to find out if somebody came across the border into Tanzania and they threw away all their documents, maybe into the toilet, and you suspect they came from South Africa, and they don't have a single document, would you then take them to court and say they should be deported, or what would you do with them? Because it seems to me that somebody needs to investigate. And I believe that SADC, the Southern African Development Community, would have, I don't know whether they have, but I would imagine they would have mutual legal assistance, where even if you just have copies of documents, you give them to the other state, and they will investigate on the basis of copies. So that if somebody has originals and they hide the originals, you still can get assistance from the other state to investigate on the basis of those copies. So it makes me wonder, because this man has been in for 8 years, so it means he could be there for another 20 or 30. We don't know. So suppose somebody came without any documents, what would you do with him? You investigate, and you seek the assistance of other states.
Yeah. Well, I don't know, but for this case, investigation was done. Relevant embassies were contacted for that. The Ministry of Foreign Affairs did that job. We have an officer from the ministry. If you would want to hear, it can come from the bench, not us. We're not calling her as our witness. She can maybe say something on that, but the relevant embassies were contacted, and my colleague Sarah Kiki, I guess you talked about the UK, the communication that we did with the UK embassy. The South African embassy has been with us all along. So really, I don't know what.
Let's have the documents. Let's have the
we have them. The UK document, we have a copy.
The UK, the South African embassy. Let's have the original document.
The one we talked about. It's here. It's available. Yes.
Yes. Yes, this new gecko.
Thank you, Mr. President.
Sorry, Honorable President, there was a question that was put to me by Honorable Justice Rafa, and I would like to respond to that. It was on the content of the court and what was the content consist of. I would like to respond, Honorable President, Honorable Justices, as follows. In the High Court judgment, at page 12 of the judgment, for the leave of the court, I would like to read as follows. The State Attorney was Mr. Luoga, put to the court as follows. Honorable Judge, the matter is coming up for reading the charge to the accused for contempt of court. And the court had this to say, court, on 28th of 2011, When this court was receiving additional evidence in respect of the appeal by the appellant John, son of Robert Mathieu Delan, the said appellant deliberately tore into pieces a document, I repeat, Honorable Justice, a document which was intended to be produced as an exhibit by the witness who had just given evidence and was under examination by the state attorney. Honorable Justice, I would like to repeat this as a document. It has not been clarified that what sort of a document was that. The judgment of the court justice spelled that a document. So it could be any document the court did not see, so it's not true as it was put by the respondent that it was either a birth certificate or a traveling document, because it is not specified in the judgment here. Thank
you. Thank you, Mr. President. As a follow-up on the responses given by both counsels, first of all, I have a request to both of them. They have mentioned a certain number of documents, both of them, which are not necessarily already in the file before this court. For instance, the respondent state has mentioned, reiterated, there are some letters to embassies, some not verbal, maybe also the letter from the applicant to request for a permanent residence, some pages on passports mentioning various visas granted to the applicant, etc. So our request would be to both parties, if the President and the court are in agreement, to grant you 15 days from now to submit to the court all the documents you have referred to during the present public hearing, so the court can look at them and make its determination. Secondly, again as a follow-up, but now to the applicant, I would like, coming back to the alleged, for you it's an alleged new application before the High Court. When you were responding to our previous question, you said definitely no, that there is no a new application or a new case pending before the High Court and related to the nationality of the applicant. I would like you to confirm here and now before this court if really there is no case pending before the High Court, because we heard firmly the respondent state giving some details on that case. Secondly, still to the applicant, you were asked whether the applicant has a Tanzanian passport. In your response, you just said that you have an emergency travel document, which were given yesterday. So you didn't really respond to the question, apart from saying that on the emergency travel document, there is a mention that the ordinary passport is being proceeded. But now what we need to know, in the end, has the applicant got or not a Tanzanian passport? The other thing being that from our reading in this emergency travel document, we don't see clearly the date of that document. If you have some information on that date, it will assist the court as well. I hope you have got the clarification to our previous question on that. Finally, to the respondent state, a further clarification on whether there exists or not in Tanzania legal system a judicial remedy against a deportation decision taken by the administrative authority. Yesterday, if I'm not mistaken, the witness coming from the immigration department was asked the same question. And he said there is no judicial remedy against a deportation decision taken by an administrative authority. I think it is in the record. But now you have stated the opposite. You have said that there is also always a possibility for the deportee to request for a judicial review of the deportation decision. So, in front of this contradiction between your own witness and your own statements, the court would appreciate to know what is what. Thank you.
Honorable President and Honorable Justices of the Court, responding for the first question from Honorable Judge, our response is, according to the applicant, they are not aware of an application pending right now. That's why I put into the court that the alleged part was supposed to prove, and they should have tendered since yesterday during the hearing that indeed there is an application or any matter pending before any court in Tanzania. Since they have not tendered it from yesterday to now, it is approved that there is no any pending case. And if they are going to produce any now, it is an afterthought.
But from your own knowledge, regardless of the issue of burden of proof, is there an application or not?
Please, the microphone, you can use this one. Yeah.
Honorable Judge, according to the applicant mother, her response right to me is, I don't know, I think so, or I am not so sure. So I would like to respond just as I got the answer. And Honorable Judge, the question that whether he had a passport before, the applicant mother also is informing me right now that the applicant used to travel on her own passport, and then he used to apply for an emergency traveling document because he never used to travel far from East Africa. And for the last question, that the traveling document does not show a date, as an officer of the court, I should also be honest that I also don't see the year. I only see 16 December. I don't see the year when you...
It should be 210 because I had another copy. I think I forgot it. It's the year 210.
But the applicant mother is telling me that the clear copy is 2010. But I can't prove that because the document I have does not show the year. And after 15 days, if we can produce those available documents, the answer is yes, according also to the applicant's mother.
I have asked the question. The respondent now.
Thank you, Mr. President. Honorable judges, before we proceed, we're seeking clarification with the response made by the applicant. Thank you, Mr. President, honorable judges. We're seeking clarification with the response by the applicant with regard to the passport of her son. We heard that she said that her son was traveling on her passport and would occasionally be using a travel document. We wanted clarification if this is exactly what the...
Interprétation encore. L'interprétation. Interprétation, s'il vous plaît. Ben si, le représentant de l'État a pris la parole. Okay.
Thank you, Mr. President, honorable judges. We were seeking clarification with regard to the response by the applicant when she was asked as to the whereabouts of the applicant's alleged mother, the whereabouts of the applicant's passport. If we heard clearly, she said that the applicant has been using her passport and would occasionally leave the country with an emergency travel document. We wanted to ascertain if this is, so that we can respond accordingly, if this is what she said.
Respondent, your answer was for the applicant or for the judges?
For the applicant. We wanted to respond to what was stated, but we wanted clarification as to what she'd said.
But the question of the judge, or you will respond now?
No, because they responded.
They responded, yeah.
She wants clarification on the response.
But what about the question of the...
Yes, the question of the judge with regard to the remedy.
Yeah.
Yes.
Okay, you respond to that and you will seek the clarification, okay?
Thank you. As stated, the position is that an order made by the minister can be challenged in the court of law under the Law Reform, Fatal Accidents and Miscellaneous Provisions Act by praying to the court to quash the decision of the minister. This is by form of judicial review.
Could you please repeat the act you are referring to for that slowly so we can take note?
Yes, my lord. It is the Law Reform, Fatal Accidents, the Law Reform, Fatal Accidents and Miscellaneous Provisions Act, cap number 310, revised edition of 2004. This was attached, it was annexed to our reply to the, it was annexed.
Okay, now the clarification you were seeking.
Thank you, Mr. President. We were seeking clarification as to the response of the alleged mother of the applicant when she was asked about the passport, the Tanzanian passport of her alleged son.
Thank you, Honorable President. First, I will not have a reply or clarify that because then it would have amount to a cross-examination. That question should have been put by honorable judges to the applicant, witness, if they saw that it need a clarification, and not the respondent, because at this time the respondent have got no time to do so. Because that will amount to a cross-examination which has been closed.
Thank you. This is a kind of response also.
Yes, as officers of the court, it was also, depending on clarification, we would have put the position of the law with regard to the age of a person to be able to travel on their mother's passport. That was our intention with asking the question.
Okay, thank you very much. This put an end to the public hearing. We'll just ask the parties, respondent and the applicant, to provide all necessary documents the court have asked during the present sitting, the present public hearing, and you have 15 days. Is it okay? 15 days from today to provide all documents. Of course, documents you talk about during the public hearing and that you have not previously submitted to the court. Thank you very much. Okay, thank you.